The next case on this morning's docket is cause number 07-24-00075-CV. Margaret Hosseini Browder versus Armando Mendes in We Care Wildlife Sanctuary. What says appellant?
Michael Ritter on behalf of Margaret Hosseini Browder.
Thank you. And what says the appellee? And Ms. Hardy, you're arguing today?
Yes.
Thank you. Mr. Ritter, as appellant, you'll have 20 minutes and a 5-minute rebuttal. Ms. Hardy, you'll have 20 minutes for argument. Mr. Ritter.
May it please the court.
Mr. Ritter.
There's a lot going on in this case, factually, procedurally, and legally. But to summarize up the points and start with the beginning of the analysis, Ms. Hosseini Browder is requesting reversal and rendition of judgment as to appellee's 2 claims under the Deceptive Trade Practices Act, or DTPA, and their defamation claims. Ms. Hosseini Browder is also seeking a reversal of the trial court's grant of summary judgment on her Texas Theft Liability Act claim, or the TTLA claim that was dismissed on summary judgment. And with all the issues, legal sufficiency, factual sufficiency, evidentiary rulings, I thought it'd be helpful to just draw an outline for the court of the relief that's being requested, starting with the greatest relief and the main arguments for those and working our way down. So for the DTPA claim, Ms. Hosseini Browder is requesting reversal and rendition of a take-nothing judgment on the DTPA claims because there's no evidence that the DTPA violations caused any damages in this case. An essential thing to understand about the DTPA claim, as opposed to the defamation claim, is the distinction between presumed damages and damages that are an essential element of the claim to establish liability. So for the DTPA claim, the Supreme Court has ruled in Gulf States Utility versus Lowe that nominal damages are not available under the DTPA. What that means is that even if you establish that there is a DTPA violation, there is no liability, no damages, and no attorney's fees unless there is establishment of an actual damages as a result of the DTPA violation.
Was there an objection to the charge on the DTPA damages interrogatory?
So as to the, no, I do not believe so. So the sufficiency.
So, you know, under Walmart against Sturgis and some other cases, the law, there is law in Texas, and then there's the law that we go by in jury trials based upon what the correct jury charge says, whether there's an objection or not an objection. Does that bind us here?
Yes, I believe so. If there's no objection to the jury charge, then the sufficiency of the evidence is going to be measured against the charges given. With regard to the DTPA interrogatory submitted to the jury, they were actually charged on 2 different double causation standards. One is the ordinary producing cost standard, which is what the law says. And then with regard to the second question involved, it's the proximate cost standard. So that's the way it was submitted. There was no objections. Both parties agreed. So we are looking at even a heightened standard from what the case law says here. So that is an additional argument. But even if we were to go with what the case law says, there's sufficient case law to establish there's no damages, which means there's no initial damages, there's no treble damages, and there's no attorney's fees. Alternatively, Ms. Hosseini Browder seeks a reversal and remand for a new trial on the factual sufficiency issues as to liability on the DTPA claim. And an alternative to that, if the court determines there's legally factually sufficient evidence to support that there's violation and some damages, that the amount of damages is not supported by factually.
Wouldn't you agree that there's at least some damages? There's damages of alleged delays in getting records back, in not being able to file tax returns, and in whatever expenses it took to try to unbundle some of these things with the documents. That would constitute some damages, would it not?
I would say that it constitutes a harm, but it is not damages as the law requires for DTPA damages to be economic damages. So the harm here from the DTPA claim stems from three things. One is that Ms. Hosseini Browder did not file the 2019 Form 990 for We Care Wildlife Sanctuary. That is the basis for the initial claim. The second harm stems from the failure to return a banker's box that was requested during litigation in this case. The request for the banker's box was made in May of 2021, and this lawsuit was filed in March of 2020. So that's the second harm. And the third harm is setting up an LLC without completing the process to register that LLC as a distinct legal entity as a nonprofit with the IRS. However, the Florida corporation was still existing at that time. And so the issue was really whether this corporation is authorized to do business in the state of Texas. And there are a lot of conflation of entity formation issues and distinct legal entities, and then their tax status with the IRS. So you have state law matters with entities, and then you have federal law issues with taxes. And those are really getting overlapped here. And to address your question, Justice Doss, about the process of trying to recomplete that paperwork. There was no evidence that they actually incurred any damages to, they incurred any expenses to recreate those documents. There's no evidence that.
Monetary amount.
What?
No monetary amount.
Correct. There's no monetary amount for recreating those documents. We don't know what those documents are. There's no testimony as to what was contained in that box. And we also know that it only pertained to the 2019 IRS paperwork, because the box was given to Ms. Hosseini Browder, according to Mr. Mendes' testimony, to do the 2019 paperwork. But that doesn't explain why We Care Wildlife Sanctuary failed to file its tax returns for 2020 and for 2021. And according to John Buxey's admissions, their IRS nonprofit status was revoked in 2022. As a matter of law, the IRS will not revoke a nonprofit's exempt status unless you fail to file your nonprofit 990 for 3 consecutive years. So the question is Ms. Hosseini Browder responsible for We Care not filing their tax returns in 2020 and 2021? And so we have to take a look at what was the evidence before the jury. What were the facts? Well, we know that in March of 2020, this relationship went south in a big, significant way. And it had nothing to do with anyone's tax returns. It has to do with the other part of this case, which is the alleged theft of monkeys and the Facebook war that occurred in mid-March of 2020. But to address a point real quickly as to Mr. Mendes's damages for DTPA, Mr. Mendes told the jury there were no problems with my tax returns. The jury still awarded some damages of $2, indicating that the jury wasn't quite sure what the damages were here, perhaps nominal damages. Maybe there's some issue getting that confused with the presumed damages for the defamation claim. However, when someone tells the jury there was nothing wrong with my tax returns, she did them completely fine, then there is no damages resulting from any DTPA violation. The only evidence the police have cited is Buxey's testimony that because Elite Tax set up We Care as an LLC, they created a new entity LLC, and Mr. Mendes was the sole member, that any donations or income that went to the LLC would be passed through to Mr. Mendes. However, there's no evidence that the LLC actually received any donations, that it was used at all. And so Mr. Mendes has established $0 in damages. And that's important, even though it's only a $2 damages award, because there's a $166,000 attorney's fees bill attached to that $2 award. So with regard to those damages, we're asking for a reversal and rendition of judgment as to Mr. Mendes' attorneys, as to the damages to Mr. Mendes and his attorney's fees, as well as to We Care Wildlife Sanctuary. The police have raised an issue about whether these issues were preserved, because there was an argument raised about suing in the right capacity, whether it should be Ms. Hosseini Browder individually or Elite Tax. However, the arguments in the record indicate that there was a motion for a directed verdict, there was a motion for a new trial that raised these legal sufficiency issues, and therefore they are preserved as to these damages issues. And that's the Arkoma Basin case. And so what's unique about this is that the motion for a new trial lists a bunch of the interrogatories and says there's no legally insufficient evidence of D5, D7, those are the damages questions. There's factually insufficient evidence of these other findings. And then it goes on to brief some of those points. And what ARCOMA stands for is that the bare minimum that you have to do in a motion for a new trial and post-trial practice is just to identify the question and say there is legally insufficient evidence of this finding. In particular, in here, cases such as this one, where you have a granulated findings of the elements into different questions. This was a single broad form question. Did Ms. Hosseini-Browder breach the DTPA and included all of this into one question? Then a general sufficiency challenge would not be sufficient to know what elements are being challenged. Here we know what elements are being challenged. There is preservation of error. I'd like to draw the court's attention to the Holscher Services case and the Boys Club case that was actually decided by this court and affirmed by the Texas Supreme Court, which establishes that when there's a new and independent cause that interferes with the DTPA violation and the damages that are being claimed, that new independent cause cuts off the producing causation of those damages.
Is new and independent cause an independent interrogatory that the jury has to be asked about?
No, Your Honor, because it is part of the producing cause standard. Now, there was some question in, I believe it was either Holscher or Boys Club, where there was a concurrence that said there needed to be a separate question, but that was not the position adopted by the majority.
How is that not included as just an ordinary part of legal insufficiency challenge then?
It is. And so the point is, whenever the jury is instructed on a legal term, and there might be other surrounding principles about how that legal term is applied by courts, the jury doesn't get the full case. They don't get the full case law discussion. Sometimes instructions will be provided based on what the evidence says, but here, the producing cause standard, courts will analyze that even as the way that it was submitted to the jury, with this new and independent cause built into.
Does there have to be an instruction for new and independent cause for the jury to know whether they have to consider that evidence or not?
No, Your Honor, because it's all part of the producing cause standard as well as the proximate cause standard, which includes but-for causation and foreseeability. So the point here is that the parties feud over the stolen monkeys was a new and independent cause. The Holscher Services case indicates that there was new independent cause cutting off causation of damages when two parties were engaged in litigation over a piece of equipment. One party decided to stop doing business with the party they were in litigation with as a litigation strategy to force settlement. The other party the plaintiff tried to claim damages and lost profits because if there wasn't that DTPA violation, they wouldn't have gotten involved in this litigation. They wouldn't have lost that business. And what the court held, the Fort Worth court held, was that the litigation between the parties was a new and independent cause that cuts off reliance damages. And here, whenever you hire a professional to do work for you, you then get into a dispute with that professional about stealing property from you. You have them arrested. You have a Facebook fight with them, and you essentially ban them from your property or remove them from your board. I think at that point, the undisputed fact would show that that's a new and independent cause that did not result in any damages from the DTPA violation. The producing cause standard requires that the damages be a natural and probable consequence of the DTPA violation itself. The question here is, did Ms. Hosseini-Browder not file the 2019 tax forms because she wasn't a CPA, because she had a tax conviction? No, the failure to file those tax forms is different from had she filed them and done them improperly because she was not a CPA when she represented that she was. But that's not what we have here. We have a new and independent cause that cuts off damages.
Just so we're clear on the record, though, on the facts, was she able to file tax returns on behalf of clients? Was that? I'm trying to understand what her status was at that period of time. You know, sometimes you've got attorneys who are under suspension from the practice of law altogether, and other times they are under some sort of disciplinary action where they have to take continuing education or something, but they still can practice.
That's correct. So the terms of the probation for Ms. Hosseini-Browder was she was not allowed to give tax advice. According to Judge Beery, who imposed that sentence, there was a question as to whether or not that would include Ms. Hosseini-Browder from running the tax office. And the answer was no. She could run the tax office consistent with the terms of her probation. But to be a little bit more specific to that point, she had Ms. Hosseini-Browder had a valid PTIN number with the IRS, so she was able to make the filings, which she did without any problem for week Care Wildlife Sanctuary for 2017 and 2018. Another important point on the causation for DTPA is that she filed their taxes for 2 years. When they had failed, they neglected their own taxes for 2 years. She volunteered to give them a family discount to do their taxes for them. So they did not hire an accountant to do their taxes before Ms. Hosseini Browder, and they didn't hire a taxman after Ms. Hosseini Browder. So these undisputed facts go to the factual sufficiency point that even if Mr. Mendes' testimony is that if I had known that she wasn't a CPA, that she had a tax eviction, I never would have hired her. There's still no evidence that they would have hired anyone because they didn't do their taxes for any other year. With the time remaining, I'd like to address the defamation claim and a nuance with regard to the 3 different defamatory statements and the specific relief we're requesting on appeal. So for the legal sufficiency challenge to damages, we are seeking a reversal, and here's where the presumed damages come into play. A reversal and rendition of a nominal damages award of $1. And the reason why is because there's presumed damages for defamation per se. However, if you want to get more than nominal damages of $1, you need to establish that there was actual harm and damage resulting from loss of reputation. And
you've got a Castile problem on this, don't you? I mean, we've got 7 or 9 different ways the jury can reach the damages question on the entity. There wasn't an objection to the charge. And unlike the DTPA jury charge that talks about producing cause and proximate cause, the only thing that's in this interrogatory is damages resulting from defamation. So we don't have the categories of loss of reputation or earning capacity or anything else. The jury's essentially just being asked to fill in the blank.
Your Honor is absolutely correct. And that is why we challenge every single item of damages, assuming that all the items of damages were included. So we can't just—
How do we know what those items of damages are if the jury isn't asked to granulate its items of damages in the charge?
We don't. But what we do know is what was the evidence presented of those harms. And so with regard to the damages, it's an all or nothing issue for Ms. Hosseini Browder. We have to knock out every single item of damages. That means reputational damages. That means we have to knock out emotional distress damages as to the damages part. The liability part is also along the same lines because we have 3 separate questions. And our position is that there's not a Castile problem with regards to the liability issues because those are granulated out. So we know that if one of those gets knocked out, then the damages award is going to be excessive because under the Hadjidic case under the Supreme Court, that when you have multiple theories of liability that are separated out, you know which ones the jury answered yes to and no to. And
you're correct. It's really Harris County against Smith, not Castile, but we're essentially talking about the same thing, right?
Yes, Your Honor. And so for the liability question, we would have to win. So to get with regard to the legal sufficiency issue, reversal and rendition of judgment, $1, we would need to establish that there was no evidence of any category of damages. We would need to win all categories of damages because it's not granulated out. For a reversal and remand for a new trial as to liability, we would need to establish that there was insufficient evidence as to all 3 of the statements were false, because we would need— because of that very, very issue that Your Honor is talking about. And if we win one of those issues, we would still get a reversal and remand for damages because we know the damages award was excessive because one of the liability findings was invalid.
And that's where I want to focus on, if you don't mind addressing it, because I don't know that I agree on that. I think if there is any theory of liability that is still has sufficient evidence, the problem you've got is you don't know which the jury answered the question to on how it filled in the blanks. So if there's one that's insufficient under Harris County, why do you not have to say we've got to affirm the award anyway if there's some award of damages?
Because of the way that the jury question was submitted, the damages question was based on the defamation that you found, what would be compensatory damages. I think there's also a limitation based on what the evidence actually shows. And one of the important things for the defamation claim with regard to Mr. Mendes's damages is that he is trying to bootstrap his mental anguish damages to We Care Wildlife's losses, and I'll explain why. So Mr. Mendes' testimony isn't that these statements from Mrs. Cindy Browder caused him distress by itself, the sleepless nights. It was not that. It was the loss of volunteers and the loss of donors to We Care Wildlife Sanctuary. And so at every single point, we need to make clear that there are different damages that have been awarded to Mr. Mendes and to We Care Wildlife Sanctuary, where in the past it's been kind of conflated to some degree. And so the same thing with the DTPA damages. One of the explanations for why they didn't hire CPA was they don't have any money because they lost all of their supporters and their donors, which is trying to bootstrap DTPA damages onto the defamation claim that harmed We Care Wildlife Sanctuary. And so if you take each item of damages and look at them separately, we believe we would prevail on all items of damages, and I think probably the stronger position is on the three liability determinations. We would win that there's no evidence that Ms. Hosseini Browder knew or reasonably should not have known about the drug use of Mr. Mendes when he sent her an image of 8 weed bongs in his possession. There's nothing cited by the appellees in their brief showing
Was
that.
the statement about drug use or was the statement about drug addiction?
It was about the specific text of the finding was drug addiction, but drug use would probably satisfy, in our position, would be that it's substantial truth that if someone's looking at the statement, the defamatory sting is the same.
Your time is up. Thank you. You'll have 5 minutes for rebuttal.
Yeah, please the court,
Ms. Hardy.
counsel. What appellant describes as a falling out over monkeys was actually a vendetta against appellees after Mr. Mendes refused to participate in an illegal scheme and reported that to law enforcement. It was after that in March 2020 that appellant embarked on this campaign to destroy appellees. First, by publishing false statements on social media. Second, by directly contacting their supporters, their donors, and contractors to tell them not to donate because they're not taking care of the animals. They're Mendes is a drug addict, and and that they stole monkeys. All of these statements, there's plenty of evidence in the record to support that these statements were false. Mr. Ritter just referred to the drug addict allegation, which is absolutely false. Mr. Mendes testified he didn't use drugs or alcohol, and another witness substantiated that. There was nothing tying him to the picture that appellant put into evidence. And at trial, appellant did not deny making these statements, and so the jury correctly found that the statements were false and damaging. Now, regarding the mental anguish, Mendes testified that the defamation caused him to be depressed, stressed, experience anxiety, sleepless nights, worrying about his animals. He testified he did not want to go out in public, and he became a recluse. The jury was able to observe his demeanor when he testified and how this impacted him. Other witnesses supported this testimony. There was testimony regarding threats to get rid of him and the negative attitudes towards him in the community. Witnesses described a change in his demeanor after the defamation. The jury found these witnesses and Mendes to be credible, and we must defer to their credibility choices. Similar cases where
Well, I don't know that I agree with that. The Supreme Court has addressed mental anguish damages in the context of defamation on a couple of times in Button against Bentley, Hancock, and Hancock relied on the Parkway standard. So I think we look at that, Parkway against Woodruff. The court has said that feeling loss of sleep, inconvenience, worrying about what's going on with your reputation in general, that that's not legally sufficient evidence of mental anguish, right?
In Bentley, and that's one case that I consider to be similar to the present case, and that was a Texas 2002 case. In that case, the plaintiff testified he worried, lost sleep, suffered from stress. He was distressed about the impact the statements had on him and his family, and that was upheld as sufficient. And that is similar to the testimony in this case. There's also Anderson v. Durant, a Supreme Court case 2018, where the plaintiff testified to depression, anxiety, trouble sleeping, and worried about his family's future, change in demeanor. And that's also similar, I believe, to what was testified in this case.
Was there any testimony related to any type of like physical manifestations from the mental anguish, like ulcers or losing hair or anything of that nature?
I don't recall anything about losing hair, but there was the trouble sleeping and the fear and anxiety and worry. But it went beyond, he became a recluse. There was witnesses that testified prior to this, very outgoing, very involved in the community. And then after this, he just shut himself in, which I believe would be similar to the Cullen v. White case, San Antonio case, where the plaintiff isolated herself and lost energy, and that was upheld as sufficient for, to meet the standard.
Do you recall in Judge Bunton's case, whether the jury was asked granulated questions on defamation?
No, I do not. Now, the award of damages, well, first of all, in terms of reputation, since the statements were defamatory per se, it's presumed that there was reputation harm. And there was evidence that the defamation was believed by the community. And according to the Supreme Court, conclusive proof is not required, rather a reasonable inference that it was, that appellee's reputation was changed to the worst is sufficient. And I would submit that based on the immediate and drastic reduction in volunteers and donations, it was reasonable for the jury to conclude that the defamatory allegations were believed by the community. Mendes was awarded $95,998 damages, and We Care $168,000. And these are reasonable to comparable awards in similar cases. Again, I would cite Anderson v. Durant on remand, $300,000 was deemed to be reasonable. And that, again, is a case that had similar testimony regarding how the defamation impacted the plaintiff. And then Benton v. Button, excuse me, $150,000 was upheld. And then again, Cullen v. White, the San Antonio case, $100,000 for mental anguish and damage to reputation. I'm sorry. And then there's a Tranum v. Broadway case out of Waco, where $325,000 was upheld for damages to reputation and mental anguish. In addition, We Care had economic damages. They lost donations. Board member testified that donations went significantly and suddenly down. And We Care was told the reason was that appellate was telling people in the community to stop donating. The manager of Juke Mills, a feed store, testified to significant drop in donations. At one point prior to the defamation, We Care had the second highest purchase volume, and by the time of trial, they weren't even in the top 20. The uncontroverted evidence showed that We Care lost at least 50% of their volunteers. And prior to the defamation, We Care held events and fundraisers where the community would get together. Afterwards, there was nothing. So the jury verdict regarding the award of damages on the defamation is not so contrary to the overwhelming weight of evidence to be clearly wrong. And the uncontroverted testimony regarding loss of volunteers and donations is more than a scintilla of evidence to support those damages. If there are no further questions on that, I'd like to address the DPTA. First of all, the evidence of what was in the banker box was testified to by Mendes and by, I believe, a board member as well as the CPA expert. The contents of the box were all of WeCare's financial documents, bank accounts, receipts, etc. for 2019. Without those documents, WeCare and their CPA could not, or a CPA could not file the 2019 990.
What's the connection between the refusal to give up the documents and the violation of the DTPA? If somebody came into my law office with a box of documents and I refused to give them back to the client, I may be on the hook for breach of contract. But I don't understand what the deceptive act or practice
Okay.
is. I mean, I understand the deceptive act or practice that got her into working with them, but I don't understand the connection between that and refusing to give up the documents.
Well, I would say that if appellees, and I believe they testified to this, had known that she had been convicted of fraud in federal court, had known she was on probation, had known she should not be even filing and preparing tax returns, they probably would not have wanted to trust her. And I think Mr. Mendes testified he would not have entrusted her with his financial records for WeCare.
I don't disagree with that, but the damages you're claiming flows from her refusal to give up the records.
Yes, and that is, and I'd like to explain that a little further. Prior to 2019, appellant filed 990N, the postcard, because the receipts and donations were under 50,000. In 2019, WeCare received donations in excess of 200,000, and that required a more extensive 990 form. And WeCare could not file the 990 form without that documentation. And the CPA expert testified what would be necessary to file those to file the form 990 that was necessary. And they had to file the form 990 for 2019 to go forward for 2020 and 21. And that's why they lost their 501c3, because they weren't able to do it. And the loss of the documents is critical. Mr. Mendes testified that he did try to recreate and obtain documents from the bank. He was making efforts to do this somewhat unsuccessfully, and I think there was testimony that sometimes that's very difficult. And in terms of damages on that, Mr. Buxey testified that he would estimate, based on what he knew and what needed to be done, that it would be about $12,400 for him to be able to try to file the returns, and that there would be an $800 IRS fee, and that, well, I guess between filing the forms and attempting to create the records, he estimated his fee would probably be around $12,400, and the IRS would have an $800 fee. And that's what Mr. Buxey testified in terms of cost to remedy the problems.
Your jury verdict, though, is for $360,000.
Yes, and
I candidly, I don't see how in the world you ever get to $360,000 based on your DTPA damages.
well, I would submit that they had an opportunity, and there was testimony that they could, if they had had their 501c3, have been able to participate in what is called the Bingo Fundraising Project. And that fundraising project, according to the uncontroverted testimony, would have brought in anywhere between $240,000 to $480,000 a year.
Did they ever apply to become a part of the bingo project at the time?
I believe the testimony was that they were in the process, but then they lost their 501c3. And as a
Is
result,
there any testimony from anybody with the bingo project that said we would have accepted them to be one of our beneficiaries if they had applied?
no, there was another operator that testified that she had referred, and the paperwork was in the process, but she also testified that they would need their 501c3 And so the process was never finished because they lost their.
I guess that's my
501.
my point. How do we know? I mean, how do we know other than speculation that this money ever would have flowed in? It seems like there are several missing steps in the middle of the process from the time of we would have applied, but we didn't, to we should be getting $360,000, part of which came from the bingo project.
I understand the only testimony, and there was no controversion to it, there was nothing contradicting it, was I run a sanctuary. I'm not qualified. This is what Ms. Wengler said, because I haven't done it long enough. But We Care has been doing it, so I referred them over there, got the paperwork started, and then it's during that time period that they lost their 501(c), so obviously it started. Now, in terms of not hiring a CPA to correct this problem, first of all, there is testimony that they did hire a CPA in Florida.
Before we get too far, you, in answering Justice Doss's question, you said there was testimony that they were in the process of doing this. Who testified to that?
Ms. Wengler.
Testified that We Care or Mendes was in the
Yes.
process of going through this bingo application.
Right. Wrangler, and that's in volume 5, page 83 to 85, around that area. They had hired a CPA in Florida, then appellant took over their taxes. And at the time,
Does she have a duty to disclose her past felony convictions?
I'm not sure, but I certainly would want to know that before I hired and entrusted someone with all my confidential documents. And I think the general consumer would want to know if that was an issue. And she shouldn't have been filing them anyway.
But she could file them. She had a valid number. She just couldn't give tax advice.
Well, I think the probation prohibited her from preparing tax returns. I believe it's in
She
the
couldn't
record.
prepare them, but she could file them. That's what you're.
Right, but she was preparing them. Yes, that's what it says.
So the deceptive act then is what? I will prepare your tax returns?
The deceptive act was that she claimed to be a CPA, claimed that she was competent to prepare their taxes and set up their documents. And then she turned around and did not file what she should have filed in terms of setting up the LLC and in Texas, instead of setting up an LLC, which she couldn't do to get the 501(c) status, because the LLC must be wholly owned by other 501(c) organizations or governments. You can't have individuals as a member in order to be eligible for 501(c)(3) status. But before I run out of time, I'd like to say that at the time that this all came about, in terms of an intervening and what they should do to minimize their damages, we have to remember appellant sued Mendes and ultimately sued We Care, took a default judgment against Mendes that had to be set aside. And during this time, there was a drastic reduction in donations. They had no money to hire a CPA. They hired money, they did hire attorneys, but eventually had trouble paying attorneys, had trouble paying their vet. They had no funds to hire a CPA to correct the problem, and that there was testimony regarding that at trial. And they needed those documents. The demands were made for the documents prior to litigation, but once attorneys got involved, of course, we requested the return of the documents as well.
Let's say, hypothetically speaking, it's just a normal CPA, okay? And they have, somebody turns over their documents, a banker box, hey, help me with my tax returns. And then they lose that banker box or they don't return it. That's some type of like either malpractice or bailment type issue. Why is this case different? Why is now it deceptive?
Because I think it's unconscionable to withhold documents. when you have the ability to return them. And this was part of her retaliation. This all came about. Everything's going along fine until Mr. Mendes says, I'm not going to burn camel dung. I'm not going to lie on an affidavit, and I'm going to report it to law enforcement. And then she gets arrested. Then all of this happens. All of this happens. Well, I'm not going to give you your box back. I'm going to go in the community and tell people, don't donate to these people. It all happened in the March, in that time frame. It was retaliation. That's unconscionable. It wasn't accidentally losing documents. It's, I'm not going to give them back to you. Before I run out of time, I need to address quickly the Theft Liability Act issue. The Shoemaker case, San Antonio case, cited on page 3 of appellant's reply brief, was decided after we filed our brief. And obviously, since it's San Antonio, we agree it's controlling. But we don't believe it requires a reversal in this case because the excluded evidence would not have changed the result. None of the excluded evidence addressed the issue of intent to deprive or supported that issue. Exhibit 4, text between Santiago and appellant. There's no refusal to return the monkey Elvis. In fact, in one of the messages, Santiago suggests a meeting at a public location to retrieve the property. Exhibit 5 is an unsigned letter dated April 2, 2020. No proof it was sent or received. And this is dated after appellant had already sworn in an affidavit filed with the court that Malcolm belonged to Mendes. Exhibit 6 was an incomplete notes from law enforcement and notes that a third-party appellant's daughter was claiming ownership. Nothing shows intent to deprive. And then the vet record's the same. I'm out of time, but we ask that the court affirm the judgment, both summary and the jury verdict.
Can I ask one question?
Sure, please.
It looked like from the record that one of the monkeys had died before
Yes.
trial.
Yes, Malcolm,
Malcolm had died? Okay.
thank you.
Mr. Ritter, you'll have 5 minutes.
Thank you, Your Honor. To address defamation damages briefly, the cases of Anderson and Guerra established that there needs to be some sort of objective way to determine that the mental anguish damages are actually verifiable, which includes physical manifestations or going to seek medical treatment. Those are the standards that in Guerra that is distinguished between the damages award to the wife as opposed to the daughters. They all testified to loss of sleep, concern about other things, but that was the standard. Here we don't have either of those two objective evidence of either of those objective manifestations of emotional distress. With regard to reputational damages, the law requires that somebody actually believe the false statement. It cannot just be that somebody said something bad, the community discussed it and was kind of like, we don't know what's going on, so we're staying out of it. Here, every single witness that testified as to, with one exception, every single witness testified, this was a bunch of negativity. We didn't want to bring our families into this negativity during post-COVID, Tiger King, everything going on at that particular time.
But part of the negativity at the time was a discussion about whether clients were stealing animals, right?
Yeah, absolutely. But the law establishes that to get reputational damages, that there was a harm to your reputation, that somebody actually believed the false statement. The closest that appellees get to that evidence is the testimony of Christy Mays, who testified that she held a negative opinion about We Care for a while. But she also testified that she didn't believe a single thing that Ms. Hosseini Browder said, because knowing Mendes, she just didn't believe any of it. And so even though there was this negativity, that negativity alone, even if they believe it or not, it really goes to the falsity of the statement. And that's where the damages need to come from in terms of your reputation, not the fact that you have a dispute with somebody over whether a monkey was stolen, because this gets into the litigation itself. That's where the truth gets battled out, is in court. So with regard to reputational damages and mental anguish damages, we believe that that even with the evidence that was discussed before, there's no evidence of those damages, and the range of damages, it needs to be resubmitted at least for a new trial on damages. With regard to the DTPA damages for revocation of the 501c3 status, appellees just represented to the court that without filing 1 year of a tax return, you cannot file any subsequent year for a tax return. If you don't file your 1040 for 1 year, suppose you don't get your W-2, does that mean you're off the hook for all future years to file income tax returns? The answer is no. And here we know, based on what was just represented to the court, that when you make under $50,000 in donations for a nonprofit, you file the easy form. They also have established that they lost all their donations going into 2020. The record establishes that there were 5 donors in 2019. Mr. Mendes sent Ms. Hosseini Browder a list of 5 donors. 4 of them contributed a total of $3,100. The other one was mega donor Mary Smith, who donated over $1.5 million during that year. So yes, that 2019 year, more significant, maybe requires a CPA. However, what are the damages from not filing a 2019 tax return? They're trying to establish this range of damages up to $336,000, which gets trebled to $1 million based on the subsequent chain of events with regard to 2019 not filed. No explanation for why 2020 wasn't filed. No explanation for 2021. IRS revokes status for the nonprofit. That is the reason why appellees say they're entitled to $1 million on the DTPA judgment, that and the knowing violation. And so for that, we request a rendition of judgment initially, and if not, a reversal and remand for a new trial on liability and as to damages. Unless there's any questions for me, I'll give 45 seconds back to the court. All right. Thank you, Your Honor.
Very much. Thank you for your arguments. The case is submitted. And we'd like to thank Chief Rebecca Martinez in the 4th Court of Appeals for hosting us. And if there's nothing else, we will be in recess. Thank you.
All rise.